Senator Leno. SB 124. Yep.
I'll return that courtesy as well.
Thank you, Madam Chair and committee members. To begin with, please to accept the suggested amendment on page 7 of the analysis as an author's amendment.
Thank you.
So the bill, SB 124, deals with the subject of solitary confinement for those under the age of 18. And I will make the case that we as a legislature have really failed not only our youth who are in our custody, but also the institutions that manage them while they are in custody, because we haven't even defined in statute what solitary confinement is. This bill will take care of that. We also have not done our job in putting forward any standards of when it should be used. As a result, there are youth as wards who suffer the ramifications of solitary confinement, and the cities and counties, or more specifically, the state and local entities that make use of it also find themselves at risk of lawsuits, and there are a number of them pending right now as a result of our lack of setting any standards. It was in 2011 that the United Nations called on all countries to ban solitary confinement with an absolute prohibition in the case of juveniles and people with mental disabilities. In 2011, there was an audit that found that youth in state facilities were often isolated in their cells for 23 hours a day or more. Now, you'll hear from the opposition, with whom I've worked so successfully in recent years on other issues that have been before this committee, specifically community corrections. We happen to have a current disagreement with regard to this issue. I want to continue working with them. We've met in recent weeks. Unfortunately, we haven't received any suggested amendments as to how this might better work for them. And I want to state from the outset that I think we are all in this together. We all have concerns for the youth that are in our charge and how best to manage many difficult situations and what the best outcomes will be for them. So we do want to work together on this. At the same time, I think it is very clear, as half dozen or more states have already moved forward with what we're trying to do in SB 124. There was a report in 2014 from the Warren Institute at UC Berkeley School of Law that found that youth in the most restrictive state program, known as Behavior Treatment Program, were typically there for 60 days. The nature of this kind of action, and we do know that it's used for punishment and for discipline, as purposes of coercion, that the outcomes are anything but good. There's absolutely no data that would suggest that using this practice under the name of solitary confinement or any other produces any benefits. There is no data that shows it is a rehabilitative effort, and it does increase the risk of suicide. In fact, nationally, over half of all of the youth who committed suicide in a correctional facility were in solitary confinement when they committed the act of suicide. So the bill is simple in the statement that the state of California will not allow for the prolonged punitive isolation of youth who are in our supervision. The definition that we would use of solitary confinement is the placement of a person in a room or cell alone with minimal or no contact with anyone other than guards, staff, or their attorneys. And it provides that solitary confinement should only be used when a person poses an immediate or substantial risk of harm to others or to the institution, and that other less restrictive options have already been exhausted. It also requires that a person only be held in solitary confinement for the minimum time necessary to address the immediate safety risk which cause the confinement, and then also enacts additional protections for persons with suicidal or self-harming behavior. So you're going to hear some very compelling testimony this morning. Again, there are any number of incidents where we know that this is using in the state. And I guess you could call them bad apples. This is not clearly the direction that most counties are moving in. In fact, there have been many reforms in recent years. But especially given the time of reform, let's put into statute both a definition and standards so that we don't repeat the mistakes of the past. And I would like to introduce David Mohammed, who is a retired Chief Probation Officer of Alameda County, and then D'Angelo Cortijo, who will give his own testimony of his experience while in a California facility. Thank you.
Thank you.
Good morning. My name is David Mohammed, and I speak today as the co-director of the California Alliance for Youth and Community Justice. To Senator Hancock and the distinguished members of this committee, I am testifying today in strong support of SB 124, a bill that would limit the harmful practice of solitary confinement of youth in the juvenile justice system. As the former Chief Probation Officer of Alameda County and the former Deputy Commissioner of Probation in New York City and the former Chief of Community Services in Washington, D.C.'s juvenile justice system, I have worked in and have administered many juvenile facilities across the country. The issue of solitary confinement has been a difficult one and challenging for many decades. There is mounting evidence and growing consensus that the use of solitary confinement is not only inhumane and detrimental, but ineffective and leads to worse youth outcomes, including the most horrifying result of suicide. Conservative columnist George Will recently wrote that the use of solitary confinement equates to torture. When I managed what has become a model facility in Washington, D.C. called New Beginnings, we implemented the Performance-Based Standards Program. PBS was created by the Council of Juvenile Correctional Administrators, a highly regarded and respected organization of directors of juvenile facilities across the country. As documented in its reports on reducing the use of solitary confinement, quote, PBS standards are clear. Isolating or confining a youth to his or her room should be used only to protect the youth from harming him or herself or others, and if used, should be brief and supervised. PBS sites must document when a youth is isolated for more than 15 minutes. Our work in Washington, D.C. was based on the successful and renowned Missouri model. The state of Missouri has long been identified as having the best and most effective juvenile facilities. Missouri very rarely uses separation rooms, and when they do, it is only for a very brief time. When Alameda County built its new juvenile facility and opened in 2007, it did not replicate the old boys control unit that existed in the old juvenile hall. Boys control was an entire unit for solitary confinement. Recognizing that it was costly and harmful, the county did not build such a unit in the new facility. When I became Chief Probation Officer of Alameda County, we began significantly reducing the use of solitary confinement, which was already declining. We were also planning to become a PBS facility, which means we were adopting the policy that solitary confinement would only be used as an immediate and urgent tactic to calm a youth down temporarily after an incident. But as soon as the youth is safe and calm, the solitary confinement would end, with the goal of the time of confinement not being more than 15 minutes. I was recently among a delegation of experts who was asked to visit Rikers Island by the New York City Mayor's office to offer ideas on how to end solitary confinement of adolescents in that facility. The adolescent solitary confinement unit was horrifying, with young people spending 90 days in 23-hour-a-day rooms. But the city has since closed the unit and have ended and abolished the practice of solitary confinement. California must do the same. There is some discussion that solitary confinement does not happen in county facilities in California, and I wish that were true across the board. Though I agree there has been great significant progress in the last several years. But if correctional administrators say this doesn't happen, then certainly there should be no opposition to this bill. Solitary confinement, regardless of what other name we put on it, is harmful and ineffective. I have always been very concerned about the safety of youth and staff in juvenile facilities. Solitary confinement actually makes youth and staff less safe. SB 124 proposes a policy that is safe, effective, and humane. I strongly urge members of this committee to support SB 124. Thank you.
Thank you.
Good morning, Senator. Good morning, Senators. My name is D'Angelo Cortillo. I am 21 years old. Today, I'd like to share my experiences while in solitary confinement. At the age of 3, I witnessed my mother attempt suicide. Years later, I was placed with my father where I was sexually abused. I was then placed in over a dozen foster homes over a 2-year period. What happened with my mom and my dad, it really messed me up. I felt unloved. I couldn't understand why I was abused and abandoned. I was confused and angry, and I ended up doing some stupid things. At the age of 12, I entered the juvenile justice system, initially for vandalism. This is where I had my first experience in solitary confinement. I was at the Juvenile Justice Center in San Francisco. As I would stare out of my cell window, I could see the other kids outside, and I remember feeling empty, afraid, and angry. Sometimes I would completely lose it, and on several occasions contemplated suicide. For an argument or a physical altercation, I would be locked up in my cell for months. What I needed was someone to talk to, someone who was able to understand me. These experiences lasted on and off for a period of 9 years. My most recent experience with solitary confinement was in 2014 while in DJJ at Chad's IBTM unit. I was locked in my cell for 2 months and I had to spend at least 21 hours a day in my cell. I started to feel desperate, like the walls were closing in on me. I kept thinking, I could be in college right now, but instead I'm just wasting away in here. When I was taken out of my cell, I would be forced to be fully shackled. Wrists, feet, black box, and locked in a small cage in the recreation yard for up to 3 hours. I was not allowed to wear shoes or a jacket. It was like I'm outside, but I'm still in shackles and I'm still alone, just with a staff member watching me. I did not receive educational or vocational services while under this program. Today, I am still affected by these experiences. I am afraid of being alone, and it is difficult to cope with some day-to-day activities. When I leave work at 5 p.m., I dread being alone. My stomach drops and a feeling of great emptiness overtakes me. Not only was my childhood messed up, but even now, I'm still messed up. I went into juvenile hall feeling angry and confused and thought that I could get some counseling or something to get better, but I ended up coming out of the system feeling even worse than when I went in. SB 124 will allow for young people like me a better chance and opportunity to re-enter society a healthy person. I am now a student at Chabot College and an intern at the National Center for Youth Law. I hope that one day soon, young people like me can have a better chance at a normal life. Thank you, and please support us with SB 124.
Thank you. Thank you very much for coming and for sharing your story. Again, this is the way we learn, and we appreciate it. Hopefully, other young people won't have to go through this. Thanks.
Good morning, committee members. Jennifer Kim with the Ella Baker Center for Human Rights, one of the co-sponsors of the bill. I'm just here to answer any questions.
Thank you.
Good morning, Angela Chung with the Children's Defense Fund of California. We're a child advocacy organization, and we're also one of the co-sponsors of this bill.
Good morning. Good morning, Khalif Osagai with the California Public Defenders Association. We are also one of the co-sponsors of this bill, and really thank D'Angelo for sharing his story today.
Thank you. Others in support, please come forward. If people could make room for them at the table.
Natasha Minsker, ACLU of California, and strong support.
Actually, if the people who are in favor would leave the podium, so the others in favor can come up and
Nicole Wortelman on behalf of the Alameda County Board of Supervisors in support.
Thank you.
Linda Warner with the California Catholic Conference in strong support.
Rebecca Gonzalez, National Association of Social Workers, California chapter in support.
Joe Michael with Equality California in support. Thank you.
Going back is Drug Policy Alliance in strong support.
Gavin Baker with the Bay Area region of Bend the Arc, a Jewish Partnership for Justice, in support of SB 124.
Thank you.
Kimberly Flores, the California Coalition for Youth in support.
Lizzie Buchan, Center on Juvenile and Criminal Justice in San Francisco in support.
Sue Burrell, Youth Law Center in support.
Roger Chan from East Bay Children's Law Offices in Alameda County in support. I'm also D'Angelo's former attorney, and quite honestly, it still upsets me to hear about his experience being locked in solitary confinement at the juvenile hall and the times when I, as his attorney, was not allowed to speak to him in private and had to talk to him through the window of the door, and I was the only person allowed to have contact with him. And I've only known him as the young person that he is, not the animal that he was treated as. I urge your support.
Thank you.
Morgan Carvajal with the Hernandez Strategy Group here on behalf of the California Attorneys for Criminal Justice, also in support.
Stuart Thompson, California Medical Association. Apologize to the committee. Our position's not reflected in the analysis, but we're in strong support of the bill. Thank you.
Elizabeth Calvin from Human Rights Watch. We're in strong support of this bill.
Misty Rojo, Justice Now, strong support of the bill. Thank you.
Tim Morrison, Children Now, support.
Diana Zuniga, Californians United for Responsible Budget in support.
Robin Gilmore, Life Support Alliance, strong support.
Laurie Doyle, Conference of California Bar Associations, in strong support.
Carol Strickman, Legal Services for Prisoners with Children, strong support.
Amanda Levy, California Psychological Association, also strong support.
Thank you.
Marie Levin, California Families Against Solitary Confinement, and Prisoner Hunger Strike Solidarity Coalition in strong support.
Thank you. Others in support of the bill? Speakers in opposition to the bill?
Madam Chair, if I may, as the opposition is coming up, just to say that Mr. Cortillo, who shared his experiences, was too modest to mention that not only is he a student at Chabot College, but he has every intention of being accepted at UC Berkeley next year with the hopes of going on to become a lawyer so he can continue his advocacy.
That's a wonderful success story. And it, as I said, it gives hope to the young people that come afterwards.
Good morning, Madam Chair and members. Danielle Sanchez on behalf of the Chief Probation Officers of California in opposition today. I first want to start by thanking Senator Leno and the sponsors for working with us. We have started a wonderful dialogue with him. We share a very great partnership over many, many issues, and so we look forward to continuing our work on this really important issue. I also want to start by saying that county probation departments do not use solitary confinement. Operationally, there are instances in which, for the safety and security of the minor, that there is separation from other minors, and that is governed by Title 15 regulations under the Board of State and Community Corrections. Within those regulations, there are very stringent guidelines and standards as to how that is to be used and when, in terms of there has to be checks on the minor every 15 minutes, medical and mental health inspections to ensure that if they need to be transferred or treated appropriately, that they are. What this bill does that really, I think, complicates what our existing regulations are in Title 15 is that it creates kind of a second layer or a concurrent or dual status of requirements on juvenile facilities that kind of create disparate implementation of some of these requirements. There's a few things kind of from a technical perspective on this bill that give us great concern. First, I think, is the definition of solitary confinement. While we appreciate that the definition does seek to recognize that there are certain kind of housing limitations on what the facilities look like, that presumably under the bill and how the current definition is read, that it could apply to any minor, for example, who is resting in their room while they're ill. In many cases, there's juveniles that choose to stay in the room for some time, just as I think other youth would in different situations. And so we just want to make sure that any definition going forward would capture the various instances in which it's used, and so that it's not overly broad to presumably apply to any minor that is just not in the direct communication with another minor at that time. In terms of the mental health provisions of this bill, right now as it currently stands, it would require probation to assess the youth and then potentially transport them to a mental health facility. The types of mental health facilities I believe that are contemplated in this bill are very few and far between in the states for the access to juvenile beds. And so what we see and some of the concern from the chiefs is that if there's a case where that youth under this bill would have to be transported to a facility, the nearest facility, if a bed is in fact available for the minor, could be hundreds of miles away. And so there's really no local, I think, construct that works well as the bill is currently contemplated. Lastly, on the Juvenile Justice Commission, I think we're certainly open to looking at whether that should be expanded and how so. I think there are some concerns about, because of the role that that commission plays in doing oversight of local facilities and other kind of independent analysis locally, that having a parent of a minor currently incarcerated could create some conflicts for them then having, kind of an independent oversight. But certainly we look forward to discussing that point. So I would just conclude my comments there. We look forward to continuing to work with the senator and the sponsors on this, but it does create a very difficult issue for us to now set up a construct on a practice that we do not use and how that complicates our existing Title 15 regulations. So with that, I would ask for your no vote today. Thank you.
Thank you.
Madam Chair, Senators, Senator Leno, Alberto Tarico on behalf of the State Coalition of Probation Organizations. It's very difficult for me to be here. I share with you, as I've worked with Senator Leno for many, many years. When my client brought this bill to my attention 3 years ago, authored by Senator Yee at the time, I told them that if I was still in the legislature, I would probably vote for the bill. And they needed to explain to me why I wouldn't. So the best thing that they did was ask me to visit Sacramento, the juvenile facility here in Sacramento. And I will say that what struck me there was that, by definition, obviously the juveniles are psychologically, emotionally, even mentally, they're juveniles, they're kids, obviously. But some of them physically are not kids anymore. 16, 17-year-olds, 18-year-olds that are 6'2", 240 pounds. You add to that, to the physical element, you add that unfortunately some of these kids are very dangerous. They've been charged with murder, assault, they have gang ties. Some of these kids have even been convicted of these crimes. So they are dangerous in that sense, and they're sometimes physically imposing. So the challenge for probation officers and the juvenile detention officers on a daily basis is, how do you keep control of a facility when the staffing ratios is 10-to-1, and oftentimes you have groups of 10 together, so there's 20, so there's 2 staff, or there's 30 and there's 3 staff. And if you have one juvenile that is determined to be violent, that is determined to beat up a rival gang member, it becomes very difficult to control that situation. So in rare instances, some of these offenders are placed in, look, I'm not going to get involved in the semantics. They're placed in their rooms by themselves. You can call it whatever you want to call it. And I do empathize with the testimony earlier of the witnesses, because this practice should be rare. However, you need to be able to control the situation. So under the current language of the bill, you have a 4-hour cap. So any of you that have kids, you know that sometimes 4 hours isn't long enough to cool down your kids. So if this one offender that wants to cause trouble knows that there is a clock that's ticking, and that there cannot be a consecutive enforcement of those 4 hours. So at the end of those 4 hours, they may be literally waiting at their door and saying, it's on. My 4 hours are up, I'm coming out, and it's on again. So the question for us is, what can probation officers do at that point? How do you protect the safety of the other juveniles? How do you protect the safety of the staff, particularly with the staffing ratios that I mentioned? So if there is an altercation, if there's a fight, 2 probation officers will go deal with that. Now there are 18 other kids that are completely unsupervised. So, unfortunately, we oppose the bill. However, we do agree with almost every of the elements that have been presented today. A standard. We do agree that the use of this should be extremely limited. We do agree that there should be ongoing monitoring. By the way, Title 15 requires for every juvenile to be checked physically every 15 minutes. Most counties have gone to every 12 minutes. So these are required now under current law. Anytime a juvenile is placed under this restrictive placement, they have to be reassessed regularly. So there are restrictions in place, and we're not opposed to further restrictions to make sure that this practice is extremely rare, but there are instances where the juvenile in custody is extremely violent. And so the difficulty we have, Senator Leno and Chair Hancock and members of the committee, is that we have to be sure that there are some alternatives to make sure we can keep the facilities under control. Because if we don't have the alternative of placing them in the room for over 4 hours, then we go to options that none of us like. You have to sometimes mace or pepper spray the entire area, which is going to impact not only the problem kid, but others and staff. Or worse, you have to physically engage, which we never want to do, which creates all sorts of problems, particularly in the case of a dangerous and very large youth. So, Senator Leno, we, as always, we want to work with you. You've been a great partner for probation officers around the state of champion, as a matter of fact. So I want to make sure I say that. And you've been a champion, as has Senator Hancock, for rehabilitation. We are your partner in those efforts. We want to be your partner in this effort, but the 4-hour blanket restriction is going to be unworkable in our facilities.
Thank you. Others?
All right. Craig Brown for the California Correctional Peace Officers Association. We represent the youth correctional officers and youth correctional counselors employed in these facilities. The Division of Juvenile Justice has been under court supervision for about 10 years, has developed extensive procedures. There's 55 pages of procedures governing when you remove a kid, all designed to minimize the amount of time that the young person is in that facility, all designed to get them out as soon as possible. For example, if you put a young person in their room because of a fight, a disturbance, whatever, every 15 minutes they received counseling from a staff member trained in that. This bill totally disregards that as an interaction. Somehow a staff member, fully trained, interacting with the ward still is called solitary confinement. It's as if the staff member never talked to the young person. This bill totally discounts the efforts the staff makes to deal with that issue. More importantly, many of the issues that the probation officers have, we share about double documentation. Instead of dealing with youth and helping them get back to the main line where they need to be, we're going to spend time writing reports. This bill creates a complete overlap in reporting requirements, requires extensive documentation that is completely different than the documentation that we require already, which is extensive. Again, the courts have reviewed this. We're in compliance. Our goals are the same as the goals of Senator Leno, to get the young person out of there as soon as possible. But again, this bill creates a bureaucratic nightmare and frankly doesn't advance the cause that has already been advanced under extensive court supervision.
Thank you. Are there others in opposition?
Senators, thank you for your time.